Welcome to VidZet, your home for careful consideration of our common concerns. I'm Dr. Ted Noel. First, I'd like to apologize for the audio and video quality we've had difficulties with in the last couple of podcasts. The first one had to do with a video recorder that didn't do its job properly. The second had to do with Skype not transmitting sound and video at the same time. So we're working on those problems, looking at another solution. In the meantime, I'm going to just talk to you guys about some things that are in the news, and I'm just going to do it from notes. I'm not going to try to read every little thing that was there. And I've had my Black Rifle Coffee silencer smooth this morning, so I should be in good shape. As most of you know, and was part of the subject of our conversation with Bill Hodes, Michael Cohen, who is Donald Trump's corporate lawyer, had his office raided last week by the bad guys, namely the feds. There's all kinds of stuff has gone on about this, and the worst thing in the world was that Sean Hannity's name was revealed as Cohen's third client. Now, let's back up a little bit. The judge in this case is a lady named Kimba Wood. Now, she was appointed to the bench by Ronald Reagan, and we will recall that sometimes appointments to the bench turn out not quite the way you planned them. She's one of them. In fact, she's far enough left that Bill Clinton nominated her to be Attorney General. Now, this was after Zoe Baird, who was nominated to be Attorney General, got dumped because she had hired an illegal alien, our current term is undocumented immigrant, to be her housekeeper. And it turns out that Kimba Wood had done the same thing, even though at the time Wood did it, it was legal, and that when it became illegal, she had to let her go. So Wood was within the law, but Bill Clinton wanted her as Attorney General. That should tell you something right there. Remember the Clinton-Wood connection. As we go on, I highly recommend that you read Andrew McCarthy's piece in National Review about this, because he goes into a whole lot more detail. In any case, at the hearing, Kimba Wood heard from Cohen that he had 3 clients. And what he was attempting to do is say, look, we have attorney-client privilege. For everything we've done that is lawful, you have no right to look at it. And the 2 clients, everybody knew Donald Trump was his client. There's another guy by the name of Elliot Brody who was his client. And Cohen had done work for both of them. Now, as long as that work is legal, it is privileged. That is, the court has no right to look at it. It is private. It's part of arranging things so that the lawyer and his client are able to discuss legal activities quietly. You don't reveal whatever your strategies are for negotiations and other things. This is a fundamental underpinning of our legal system. And under the Fourth Amendment, it's protected by the provision that you have to have a warrant and no unreasonable search and seizure will go on. It's also protected under the Sixth Amendment, and you'll recall those are part of our Constitution. And Kimba Wood, as a federal judge, is bound by our Constitution. So she should have that. Not only that, she is regulated by a whole set of rules that are written down in detail in the Federal Rules of Criminal Procedure and in other regulatory stuff that talks about what's legit and what's not legit. So let's look. It says, among other things, that the public does not have a right to know certain things. We've talked about the attorney-client privilege, but the public doesn't have a right to know about every criminal prosecution. For example, the grand jury system is set up so that it's totally secret, and a grand juror who leaks is subject to sanctions. A federal prosecutor who takes things to a grand jury who leaks is subject to sanctions. So there are a number of things that are protected from public view. In any case, there is a proper way to proceed with these. And the first thing is you have to get proper warrants. And warrants are created in what's called an ex parte proceeding. That is, the legal people, the cops and so on, go to the judge and say, here's the evidence we have that so-and-so is involved in a crime, and here's where we believe the evidence will be found. They have to very specifically provide the evidence they already have. They have to specifically say where we're going, what we're looking for. You can't just go in and clean out everything. And that's very specifically specified in the Fourth Amendment. But the defendant doesn't get a representative in this. He doesn't even know about it. And that's proper. Next, once you have a question of privileged information, this should be tended to what's called legally in camera. Now, in camera is a Latin phrase. It just means in chambers. And it refers to every sort of discussion between legal teams and the judge that the public has no right to know about. And if you have an attorney-client privilege issue, that goes there. As a matter of fact, with Sean Hannity being declared to be a client, that should have gone in camera. They should have discussed that he's not party to things. He knows nothing about what's going on. And as a result, his stuff should never be exposed. Matter of fact, the fact that he is a client should not be exposed. Yet what the judge did was she took a written name from Cohen's attorney. Here's our third client. She picks it up and reads it in open court. Now, why did she do that? Oh, she let the lawyer for CNN and the New York Times into court. Guys, you don't have a right to know squat. But here you have a friend of the Clintons acting as the judge, letting people in who have no right to know anything. And what is the point of protecting him? It can destroy his reputation. So what did we see in the news? Immediately, whoa, did Hannity have an affair that Cohen was covering up? Oh, we got to be careful about this. That wasn't what went on, and Hannity got out in front and said, look, I never retained him in any formal sense for anything. But conversations between attorneys and friends don't have to be compensated to be attorney-client privileged information. That's well-established law. Judge Kimba Wood violated the law and should be sanctioned. Should we be surprised? Like I said, she's a Clintonista. Could this be payback? After all, remember, Hannity openly, vigorously opposed Hillary Clinton during the campaign. I was on his show talking about her Parkinson's. So you know that Wood has a bias. She should have recused herself, but oh no, she took a chance to, we're going to get him. There are clear rules. She should never have allowed the intervener request. That's what it's called by the New York Times and CNN attorney. She should have remembered that it is okay in court to say there is client number 3. But if you tell him by his initials, SH, that is not legitimate, because somebody might be able to figure out that Sean Hannity was the client. No, it's client number 3. It should be privileged. Everything should go and be kept in camera. I'm sorry, what we've got right now is a drastic miscarriage of justice by a Clintonista judge. These sorts of things are one of the reasons why we have Donald Trump in the White House appointing justices. He has picked justices who will follow the law. Until next time, I'm Dr. Ted Noel. Please remember, like us on Facebook, follow us at VidZ at Twitter, and support us at Patreon.